MSW Media.
The Justice Department had its worst day so far as it was forced to withdraw subpoenas of journalists and their families after a contentious hearing in Manhattan.
The Justice Department is denying it told the FBI to stand down investigating ICE shootings despite a memo saying otherwise.
A U.S. attorney appointed by the court who was fired by Donald Trump in under an hour has filed the first of its kind lawsuit challenging his termination.
And Jim Jordan, who still has not responded to his subpoena regarding January 6th, has made a criminal referral to the Justice Department for Jack Smith on perjury grounds. This is Unjustified. Hey, everybody. Welcome to episode 79 of Unjustified. It is Sunday, July 26th, 2026. I'm Allison Gill.
And I'm Andy McCabe. Allison, we have a first this week on Unjustified. This is the first time the lead story, number one, top of the fold, is about the loss of the presumption of regularity at the Department of Justice. So for the first time, we're going to open the show with a segment we like to call...
Hit me in the head with a bat.
Hit me in the head with a bat. And if I ever get off my ass and put the jingle together, we'll have a jingle to go with it. But just keep holding your breath. It's going to make it so much better when it finally happens.
Yeah, ball's in your court there.
I know. I forget it every day of every week until this moment when we start the show.
I'll keep texting you. I'll keep sending you text messages.
All right,
Call Barron.
Fair.
But yeah, you're right. This story is massive. It's absolutely massive, and it could have massive implications, negative massive implications for the Department of Justice. Anna Bauer, a friend of ours over at Lawfare, said that when she was at this hearing we're about to discuss, she heard an audible gasp from someone in the room when one of the Department of Justice lawyers said. And on Blue Sky, she explained there's only 3 times she's heard audible gasps. First, when Fani Willis showed up unannounced and demanded to testify amid her disqualification hearings in the Trump Georgia case.
Okay, crazy. Yep, okay.
Second time, when Mark Meadows' counsel called him as a witness in his federal removal hearing that he lost.
Oh, also crazy. Okay.
Also crazy. And then during this hearing.
Yeah. I mean, that's the kind of thing you expect to hear like in a movie theater of a horror show. You know, like, it's not what you get in court very often.
Well, what this DOJ lawyer said was pretty horror show.
Yes.
I mean, as far as things go, utterances that could come from a Department of Justice lawyer's mouth.
Yeah. So much so that, in fact, Chris Geidner, who's the independent legal expert that writes for Law Dork on Substack.
Oh, I love Law Dork so much.
So he's the one that said that DOJ had its worst day so far this past Thursday.
Yeah, he even put up the Simpsons cartoon, where Bart says, "This is the worst day of my life." And Homer says, "You mean the worst day of your life so far?" And instead of Bart's head, it's the Department of Justice seal. It's great. You should subscribe. Everybody listening, you should subscribe to Law Dork.
All right, I'm doing that today. Okay, so Chris writes, the degradation of the Justice Department in the second Trump administration is clear. It is having immediate effects and it will have long-term effects. Just how degraded DOJ has become was on full display in the Southern District of New York on Thursday.
Yeah, he goes on and says, to get why Thursday's happenings are so central to understanding how bad things have gotten, know that the U.S. Attorney's Office for the Southern District of New York is widely seen as one of the preeminent U.S. Attorney's offices in the nation. Alumni of the office would say it's the key office, and it was openly and sometimes derisively referred to as the Sovereign District of New York due to the high view that members of the office held of the office itself. Mm-hmm. Now, however, things are looking a little different. Over the past 2 weeks, the office tried to subpoena reporters from the New York Times and ensnared some of the reporters' family members in a second set of subpoenas for phone records. And when challenged, the office's ability to carry out basic legal research and adhere to general ethical standards were called into question by U.S. District Judge Arun Subramanian in a sharp hour-long hearing that ended with the Trump administration withdrawing the subpoenas rather than face the almost certain likelihood of Subramanian quashing them.
Inner City Press's Matthew Russell Lee covered the hearing live on Blue Sky, and Courthouse News Service covered the hearing as well, in addition, of course, to the New York Times' report. So it was an altogether horrifying appearance in court for Deputy U.S. Attorney Sean Buckley, as well as Kevin Sullivan. He's a lawyer in the office who was initially sitting in the gallery, but who Subramanian called up to sit at the counsel's table because he was, quote, on all the pleadings.
You do see do that in comedy shows. Like, everybody move to the front, fill in the front rows. Yeah. She's calling up attorneys that were in the gallery to sit at the counsel table.
It's more like getting in trouble in class. No, you get up here. Sir, get out of your seat and come up here to the front of the class.
Mm-hmm.
So yeah, he was on all of the pleadings, apparently relating to the phone provider subpoenas. And we're going to sort through that in a minute. But from the opening of the hearing, though, Subramanian, who is a Biden appointee, made it clear where things were going to end.
Yeah, he did. After Sean Buckley initially said the government didn't want to withdraw the subpoenas, but instead preferred to keep them on hold, put them on ice in abeyance, while the investigation continues, Subramanian shot back. Either we can quash the subpoenas or you can withdraw the subpoenas. As reported by the Times' Michael Grinbaum and Jonah Bromwich. But the more fundamental problem, as Subramanian soon thereafter noted, is, quote, the subpoenas are the last step, not the first step, but the last step when dealing with efforts to subpoena reporters, as Courthouse News' Eric Ubelacker reported.
Subramanian specifically referenced the New York Times versus Gonzalez, a 2006 decision from the U.S. Court of Appeals for the Second Circuit. And of course, the Second Circuit is where appeals from New York's federal courts are heard. And that case laid out the standards for addressing efforts to subpoena reporters' phone records. Addressing a qualified privilege for journalists, the government in Gonzalez had attested that it had, quote, reasonably exhausted alternative investigative means of getting the information sought. Now, the Second Circuit held that at least that step, even under compelling circumstances, was necessary before seeking reporters' records. Here, though, in opposing the New York Times motion to quash the subpoenas, the government acknowledged that, quote, there are particular investigative steps that the government is seeking to take in the near term that the government anticipates will be material to this court's assessment of the application of any qualified reporter's privilege here, which is a very complicated and hard to understand way of saying we haven't. Done those other steps yet. We're thinking about doing them. And once we do, we hope that that will influence your willingness to support our subpoenas.
Right. We'll do them later. The trust me, bro doctrine.
Exactly.
It's like vouching in a grand jury room, right?
Yeah.
Hence Subramanian's, quote, not the first step, but the last step comment, right? That's what led to that. That, however, was not all, Andy. No. As Chris Geidner reports, that Lee reported from Inner City News, Buckley said the subpoenaing of the phone records of the mother of a Times reporter and spouses was an error, adding, we own it. We used a public source database. And at that point, Subramanian shot back. It seems like the inadvertent errors and we should have done things differently are piling up.
Oh my God. Then, regarding the phone records subpoena, Subramanian called Sullivan up and matters got worse.
This is probably why he was in the gallery, not at the council table.
Yeah. Get your behind up here to the table. Okay, so this is kind of almost in transcript style. So first you have Judge. You didn't tell the judge the subpoenas were about reporters, about the New York Times? Sullivan. We did not. It was an oversight. Later, we did legal research.
Wow.
Now that was the point at which Anna Bauer heard the audible gasp.
Yeah, you didn't tell the judge that you were subpoenaing reporters? No, it was an oversight. Wow, that's quite an oversight.
I mean, it's stunning. It's stunning to read that. I can't even imagine what it was like to hear it in open court. So after saying that, the judge says, wouldn't it have been relevant to know that there had been public reporting? And then Sullivan replies, yes. So let's just frame this out a little bit. There's 2 batches of subpoenas on that infamous Friday night that all this broke open. They served subpoenas on the reporters personally, which required them to come into the grand jury and testify personally.
And
that
the
was
Times
one batch.
reported that on July 11th.
On July 11th. And of course, they did not follow DOJ policy, as weak as it is now, having been weakened by Pam Bondi, but still requires that the New York Times be notified before the subpoenas are served. They did not do that. They just showed up at these reporters' house. They also issued subpoenas to the phone providers for these reporters, seeking phone records. They did that, of course, without notice to the New York Times. They then went in front of a judge and they asked that judge for a non-disclosure order to basically prohibit the phone providers from telling the reporters that their records had been subpoenaed.
And we saw this in the Jack Smith January 6th investigation, when Jack Smith went to Twitter to get Donald Trump's Twitter account information.
Yeah.
And they had a legal battle because Twitter wanted to tell Donald Trump.
Exactly. Same
and
thing.
They were but they lost, and the judge approved that non-disclosure order.
Right. So this is a very standard kind of tactic in very sensitive investigations. Like, let's say it's a terrorism investigation and you have this terrorist phone number, you need to get their phone records. You don't want the phone company to tell the terrorists that the records have been subpoenaed. So you can get a non-disclosure order. It's got to be signed by a judge, and it usually only lasts for a limited period of time. So they did that here. But when they went to that judge, they never told the judge that the subpoenas they had submitted were for reporters' phone records.
Mm-hmm.
I mean, that is outrageous. And I think that's one of the things that Subramanian really keyed in on here.
But it gets worse because, when they say later we did some legal research.
Yeah.
There's a case governing this. Yeah.
Which they didn't even know about.
So, and that's what happened here. Subramanian went so far as to note that he would ordinarily issue an order to show cause why he shouldn't issue sanctions in a situation like this. And Buckley pointed to a footnote in their filing addressing the non-disclosure order sought in the matter. Subramanian called that insufficient to resolve his concerns, and Buckley promised it would never happen again. Somehow it still got worse. When Buckley then told Subramanian about finding the Gonzalez case, which is the governing case here.
Right.
After seeking and getting the subpoenas, the judge's question to Buckley, and Buckley's answer spoke volumes. The judge said, "You are not aware of the leading case in this field?" And Buckley said, "No."
I mean, dude, first-year law student, not even a lawyer, would know to do the research first. Oh, yeah. Okay, so there was also further discussion about DOJ's non-disclosure arguments and blame shifting surrounding them, given that, as Subramanian noted, and this Subramanian said, DOJ on July 11 has made a statement about it. So how was this appropriate? And Buckley replied, "Yes, we should have done it. I personally did not review the non-disclosure. I do not review every single piece of paper." Or apparently any of them, I guess. Wow, dude. After a short recess, everyone came back, and DOJ at that point agreed to withdraw the subpoenas.
Yeah, but that wasn't the end of it, Andy. In addition to DOJ lashing out at Subramanian and insisting, quote, "This investigation remains ongoing," the government's actions here did have consequences for the Trump administration. Subramanian issued an order a little bit later, first confirming on the record that the government has withdrawn the subpoenas. And so the motion to quash is moot because the subpoenas don't exist anymore.
Right.
Additionally, though, he also issued 3 other provisions. And in some, DOJ is ordered to come to Subramanian personally if they want to try with these subpoenas again. Subramanian will retain jurisdiction over any related matters in this investigation, subject to further briefing on the scope of that retention. And Subramanian ordered the DOJ to provide the court with additional information about the non-disclosure request by July 27th, which is tomorrow.
He's not letting that go. So specifically, he said, with respect to the July 14, 2026 application for a non-disclosure order The government should, on or before Monday, July 27, 2026, furnish to the court on an ex parte basis any internal communications on or before July 16, 2026 concerning 1, the decision to seek the non-disclosure order, 2, whether the application should or should not reference that the owners of the records were reporters, and 3, whether and when notification of the third-party subpoenas should be given to the reporters. That's deep, man. He is literally requiring them to go into their internal DOJ emails, text messages, meeting notes, whatever, and find all information that are relevant to those 3 points. And let's remember where this all started. This was the, hey, I'm Kash Patel. It's Federal Friday. I'm heading to Chicago. Oh, no, you're not. Get over to the White House, where he spent the rest of the day with Susie Wiles, basically running this investigation himself personally. So my question is, are you surprised that it is as effed up as you can possibly imagine? I mean, yeah, this is why.
And it was about leaks about the Qatari jet.
Correct. Yeah. Well, the fact that Trump couldn't take it home from Turkey because it wasn't prepared to protect him in the way that the old planes do. This thing was just an absolute mess from the first step.
Yeah. And correct me if I'm wrong, but asking for all those communications seems like step one in issuing a show cause order as to why he shouldn't hit these guys with sanctions.
Full on. Like you get the sense that he's really enraged here and he wants to come down hard on them, but he's also trying to hold himself back a little bit by not diving into the sanctions piece. Cause that'll, if he does that, then DOJ has to appeal it. And so that throws this whole thing into some sort of fight that probably won't stop until it lands on the Supreme Court's desk. So, this guy's, as we know from tracking a million of these cases, these federal judges and district court, man, they're just trying to get the job done. They're not trying to get famous in the process of doing the job. So I think he's trying to be responsible and ensure that this never happens again. So I think he's probably going to not go down the sanctions route, but that's just my prediction.
I think we're going to see a privilege declaration.
Oh, yeah. They're working on that
process,
right now.
Law enforcement privilege, blah, blah, blah privilege.
Whole 9 yards.
It's gonna get stickier, I think, before it it clears up. But
for sure.
We'll keep you posted on what happens tomorrow on the docket here. But man, you didn't tell the judge that you were subpoenaed, that they were reporters, and you didn't know Gonzalez was the case.
Unbelievable. And it's their policy.
It's their policy.
Like, you didn't have to do a lot of deep dive legal research to just follow your own rules. Rules that were notoriously weakened by Pam Bondi in April of last year. She put out that memo, the infamous Bondi memo, basically saying, no one else had the stones to do this, and we're going to start, going after reporters to get to the leakers. But even their own lax policy requires notification. Oh man, this crowd, just unbelievable.
Yeah, so that's why we had to open with Hit Me in the Head with a bat today. But there's actually another whole above the fold lead story that we're covering today. And we're going to get to it after this break. Stick around. We'll be right back. The office sought limited phone toll data from 8 senators and a member of the House in the days surrounding the January 6th assault on the Capitol. And while such records would not involve the content of any phone calls or messages, multiple Republicans have incorrectly claimed that Smith had tapped their phones or spied on them, right?
Mm-hmm.
And God, that's all they brought up in those hearings with Jackson. My phone records. Yeah. You got my phone toll records. You got my phone records. That was their major complaint.
Yes.
Like that they're being spied on. Meanwhile, you've got the Republican government gathering all of our information from the IRS and the Social Security Administration and feeding it to ICE and DHS and
demanding it from state voter rolls,
trying to put together a national citizens list. Like, tread on me, daddy. Like, what are you even talking about? If you claim so hard to care about oh, you invaded my privacy by getting my phone records. You committed a crime, bro. We were investigating it.
That's right.
That's how it goes. Records released ahead of last week's hearing indicate that contents of messages obtained by Jack Smith's teams related to messages handed over by the National Archives, not the toll records he referred to in his original answer. So he did get text messages from the archives, but that's because he was looking at executive branch messaging under the Presidential Records Act.
That's right. And the questioner didn't ask, did you get text message content from the National Archives? They said, when you served the toll record subpoena for our toll records, did you get content? And he said accurately, truthfully, directly, no. Quote, I think he should absolutely be investigated, Hawley said. Oh, I'm sure you do. I hope that you will investigate Jack Smith for perjury, and I hope that possibly you will prosecute him. So I guess Hawley is both investigator and judge and jury now. Mm. Quote, yes, Senator, Blanche said. Trump has long called for Smith to be investigated. In an interview with MS Now earlier this month, Smith said the U.S. is facing an attack on the rule of law that is different in kind and scope to anything I've seen in my lifetime.
Yeah, for sure. And we have some excerpts from the letter that Covington wrote to the DOJ. The House Judiciary Committee's referral to the Department of Justice of our client Jack Smith is based on a spurious claim that Mr. Smith provided false testimony during his 8-hour deposition, December 17, 2025. The referral is made not because Mr. Smith made a false statement. The letter concedes he did not, but because he did not proactively disclose information that was not responsive to a question asked. Right? And so, I mean, like, that's kind of the piece that I'm talking about there.
The letter goes on to say, moreover, contrary to the referral letter's assertion, the speech or debate clause was not implicated by the collection and review of text messages on the phones of White House officials. That important constitutional provision, which Mr. Smith and his team took seriously and safeguarded, protects members of Congress from having their legislative acts used against them. It does not prevent prosecutors from using or reviewing text messages between members of Congress and members of the executive branch in an investigation and prosecution of an executive branch official, Donald Trump, which is precisely what happened here.
Yeah. Yeah, and get this, because you and I talked about this when we were covering the Jack Smith investigations during discovery. The letter goes on to say Mr. Smith and his team were also transparent in disclosing all these text messages to Trump's personal counsel in discovery. If President Trump's attorneys thought that Mr. Smith and his team had done something unlawful or improper in obtaining these text messages, they could have filed a motion to that effect. Notably, they did not.
This whole thing enrages me on so many different levels. But yeah, the fundamental principle is you can't base a perjury investigation or a 1001 false statement investigation on something that someone did not say. Right. You have to have a statement. And it's not just any statement. You have to have a very clear and direct statement that was given in response to a clear and direct question. If there's any variance or we're not sure, it's ambiguous, there will not be a successful prosecution, which is why the Department of Justice routinely turns down referrals from Congress about people who allegedly lied under oath in hearings. Very, very hard to make those cases. And as a general rule, a normal Department of Justice doesn't really take them up.
No, and it's deja vu all over again, because you and I talked about this with the first Jim Comey indictment.
Yep.
About the Daniel Richman stuff when Ted Cruz was going on a tirade about you.
That's right.
And we talked about the Braunston literal truth defense.
Yeah.
And I remember that he was a movie producer that was asked if he had a Swiss bank account. He said, my business has a Swiss bank account. He also did have personal Swiss bank accounts, but that was literally the truth. And the Supreme Court overturned his perjury charge, saying it's up to the questioner to pin them down and to get the right questions. Exactly. And I also brought up the irony that that guy, Braunston, went bankrupt making a movie about the fall of Rome, which is kind of funny.
cagey guy at the witness table, but maybe not the greatest producer of judgment. I don't know. So, yeah. Okay. So the other layer here is that They're pissed at him for not giving them more information that they did not ask for. Yet, as you and I know, Jack Smith went to DOJ before this interview and said that he wanted to be able to talk about the report that's still classified in Eileen Cannon's courthouse. And they said, no, you can't talk about anything that's not classified, but sealed. And if you do, we're going to come after you. So he had to be like laser careful about everything he said, to not exceed the scope of the question, to only answer directly, don't implicate, sensitive information. So he did that effectively, denying them the opportunity to prosecute him. And now they're going to try to do it anyway. It's so offensive. And finally, the arrogance, the unbelievable arrogance of these people who absolutely think they are 100% on a different level than all of the rest of us.
You really want to throw legal hands with Jack Smith.
And you think the speech and debate clause protects the sanctity, the reverence of your communications in text messages that you sent to other people? Newsflash, dude. Once you send it out in a text message to someone else, it's gone. It is gone. It can end up anywhere. That's the same shit that the rest of us deal with every frigging day.
Right. And that's why they want to not have to hand over, remember a couple months ago, they put out a memo saying we shouldn't have to hand over our communications to the National Archives. And we think the Presidential Records Act is unconstitutional.
Right. We shouldn't have to comply with the law. Oh, it's so outrageous.
They even whipped up an OLC memo saying it's not constitutional, the Presidential Records Act. Because maybe they saw this coming down the road. It's just bonkers. But again,
despicable people.
Really horrible. And I don't think they're in this to win a conviction. They're just in it for the news, maybe a perp walk or something.
They're in it because Donald Trump wants it.
Yep.
So they're going to do it. And Todd Blanche has already said the investigation's open, and they're going to throw whatever spaghetti they have at the wall, and they're going to try to indict him. Not a question in my mind. Only one reason they'll do that is because that's what Donald Trump wants.